Hi, everyone. I'm going to talk a little bit about parents' rights in our school district. And yeah, so the Supreme Court of the United States in 2000 declared that the liberty interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberties interests recognized by the courts. I just thought that was a really good quote to start off with before we dive deeper into parents' rights. What is a parent? So in Kansas, a parent is defined as a biological parent, an adoptive parent, a person acting as a parent, legal guardian, and if an officially appointed education advocate, and a foster parent. If the foster parent hasn't been appointed, the education advocate of an exceptional child. A person acting as a parent, that is basically anybody, a relative, or anyone else who the child is living with, and that person is legally responsible for the welfare of a child. If there is more than one party that is qualified to act as a parent, the school must recognize the person that the judge deems as the legal decision maker for that child, which sometimes can be difficult because things change and going to court takes a long time. So sometimes the parent who is legally the decision maker for the child isn't the one that the school sees as the most qualified parent. So that sometimes gets difficult, but you have to follow the legal legislation on that. If parents are divorced, regardless of which parent has primary custody, the school must provide prior written notice of any special education action to both parents, even if only one parent has the right to consent, unless a court order precludes this from happening. If a parent denies consent and one gives consent, the one who denies consent can request mediation or file for due process. Parent participation. So parents have the opportunity to be a member of their child's IEP team, which they normally are, and they should be involved in designing, evaluating, and when appropriate, implementing school improvement plans. This we'll talk about a little bit more. It's part of the evaluation process is parents' input and what they see in their child. Interpreters will be provided if needed. Every child with exceptionality may receive a free appropriate public education. So, and anything that goes along with that. So, certain access to certain bathrooms or buses, that's all acceptable. It's all free of cost, even, and the school should already have that anyways. But if they didn't, for whatever reason, they would get access to that, and parents wouldn't have to pay for it. Parent right and special education notice. So schools are required to provide a copy of the parent rights and special education notice to the parents at least one time in a year, upon a referral or parent request for initial evaluation, first formal complaint or due process complaint filed in a school year, upon the removal from school that constitutes a change in placement. So, like when they go to secondary, they have to change or, to a different school. Upon parent request, parent rights notice is required with each IEP meeting, and legally these notices have to be written in a language that is understandable to the general public. So you have to kind of rewrite all of the legal jargon and make it so an average person can understand it. Parent consent must be done in writing. The parents must be fully informed to all relevant information in his or her native language or other mode of communication. So if you're deaf, then sign language, all of that. Any other, ways that you need to be informed. Parents know if any records will be released and who will receive them. Parents understand their consent is voluntary. What that means is they can revoke at any time if they no longer want to give consent for whatever they're giving consent for. And parents understand that if they revoke, consent is not retroactive. If a parent refuses consent, the school may pursue the changes if they choose by using mediation or due process changes. So that's if a parent consent is requested but not provided. The school must make a reasonable attempt to obtain consent from the parents before they no longer need consent from the parent. And that would be they have to contact the parents 2 times in 2 different ways. So either, a letter, an email, a phone call, a house visit, 2 different attempts. That is our district. We're really good about this. We do a lot of different attempts to try to get a hold of our parents. And if we don't, then we don't, obviously we don't need their consent, but we do that very well by doing it more than just twice. Parent consent is not required for reviewing existing data on an evaluation, giving a test or evaluation that's administered to all children unless consent is required by all parents. So you can give a test, just an average test or an evaluation. At our school, we do it's called a My Savers, and all the children take it, and we don't need consent from their parents. So all students take that My Savers, and it's like a social emotional survey or evaluation. Any other special education action where only a prior written notice is required. Evaluation eligibility and reevaluation. So evaluation means a variety of assessment tools, including your input, so the parents' input, your child's teachers and other service providers' observations, strategies, technically sound instruments, and procedures used in accordance with IDEA to determine whether a child qualifies as a child with a disability as defined by IDEA, and the educational needs of your child. This process can be initiated by the parent or the school. Eligibility. A copy of the evaluation report and documentation of determination of eligibility will be provided to parents for no cost. That's when they give you, all of the things, the tools that they used, the input, the input from their teachers, all of that stuff. They put it in the report, and you have access to that, obviously, for no cost, or parents have access to that for no cost. And on top of that, it's the documentation that states if they're determined for that eligibility and basically why or why not. Reevaluations must be done every 3 years or more often if needed or desired. A parent may revoke by submitting a written request. Notice of an IEP meeting. Meetings must be arranged. I don't know why that's not working. But IEP meetings must be arranged 10 days prior. And the notice must include the proposal, the date, the time, who all is going to be attending that meeting, including the child and any agencies outside of the school. Obviously, any agencies outside of the school would need permission by the parents, and location, place, and purpose of the meeting. Access rights. Parents have the right to inspect and review any educational records that are collected by the school, and schools cannot change a fee to retrieve information or charge a fee to retrieve information. And then here are my resources. Thank you very much, and have a wonderful day.